Hey, everybody.
Hello. Hi.
Welcome to No Stupid Audio Questions. We have a really special guest here today. John Riley is joining us from the U.S. Copyright Office. Is that correct? Did I say that correct?
Yes.
I was excited. I was like, "Who's the special guest?" Because
Well, welcome to No Stupid Audio Questions. Welcome, Piper. How are you doing?
I'm great, Dan. Dan and I are in the same room.
This
so
is
you
actually
might see
kind of
us
fun. We can talk through
away.
John while we do this. Yeah, welcome everybody. And a big thank you to John for joining us today. He's going to be answering all of your questions about music copyright, about licenses, about all the things that just make my head spin and that I really dislike. So I'm excited to learn myself because I have avoided this for my whole life. So I'm really excited. So we've
gotten a lot of questions, Dan, about copyright and just general law clarification things here and there. But I want to make sure that we kind of set the table here for John. John is here to answer questions specifically about copyright and to, basically tell us a little bit more about things like the difference between a sound recording and a musical work and, how some of these different entities are advocating for musicians and producers to be able to make a living. And so we're really grateful to have him here, but I want to make sure that we kind of set the table and say, look, John is not going to be answering any questions about legal matters. He is not going to be telling you how to make money in the music industry or anything like that. But we did get a ton of great questions and a few that Dan and I have to ask John directly. So we can kind of get started. And generally, y'all know you can ask questions as we go at tinystereo.com. But we may not hit them today because we have so many. But cool thing is we are going to have a little bit of a follow up around music law and general advocacy things. And we have a special guest that's going to be joining us in October for that. So anything we don't hit today or that John thinks would be better answered at a later date, he is fully allowed to say, I'm going to punt that one down the road. But John cannot say.
Yes, we got to review the rules. He cannot say it depends to any question. But I have a feeling there's going to be a lot of could be this, could be that today with this,
that's
which
fine.
We'll accept that. Hopefully that all goes well. So welcome, John. How are you doing?
Thank you. And thank you both for having me. I really appreciate being here. I'm doing well. It's still a pandemic, still working from home, but, excited to be talking to you both today and, excited to talk to the audience here. Hopefully we could get some good information to them and, get them cleared up on some questions that they have. So,
John,
Awesome.
I have two stupid questions to ask you first. Okay, so number one, how did you find us? Because when Loic told me that the government was asking about our show, I got a little bit worried, to be honest.
Mm-hmm. Well, okay. So the thing you need to know about the Copyright Office is that we are all not professional creators. We are all, professional Copyright Office employees, but there's just a ton of us who know different pieces of whether it's, music, writing, dance, video games. It's just a great group of people who are all working to support the creative industries and make sure the system as a whole works. And so I will say that my colleague and, master of finding me great places to talk, Holland, who I think you guys have met before the show started, is just amazing at finding different places to talk to. And I really think this is a great idea. I got to say that, as a very terrible amateur, I play my guitar and I wish I could do more than record it on my phone because I have Logic Pro and do I know how to use it? I do not. I'd love a resource like this. This is fantastic. So I really appreciate, that you all are doing this. And it's going to be a little different because, I don't know the answers to those audio questions, but, we'll give a little background about the law and that'll be, interesting for a twist. So.
Well, we're very excited as well.
Very happy to have you. So the second question is, what exactly do you do in the Copyright Office?
Great. So I'm an assistant general counsel. We have a few different divisions, and I think a lot of people mostly know us for copyright registration. Certainly that's one part. Other parts, though, are Public Information and Education Office, which Holland works for, and that's really doing outreach and education to people who have questions about copyright. We also have a Policy and International Affairs division. They work closely with Congress and work on a lot of international issues in copyright, so like international treaties and things like that. And then we have the Copyright Royalty Board, which some people in the audience may have heard of. They set rates and terms for statutory licenses. And if a statutory license is confusing to folks, it was confusing to me too. How is there a rule that says someone could use my work without my permission?
Right.
Well, it's a statutory license. And there's some for cable and satellite retransmission, but there's also kind of a patchwork as it applies to music. So some apply to sound recordings, some apply to musical works. And it's not even the same rights that they apply it to necessarily. So it gets really confusing. They set rates and terms for those. And we are starting a new part of the Copyright Office, the Copyright Claims Board, which was created by the CASE Act. It's a small copyright claims tribunal that is not a court, it's voluntary, but you could have your copyright disputes heard by experts, and it's in the government. So we're looking forward to that opening. It's not ready to open yet, but the bill passed, and then we're working very hard on that. And that's a long-winded way of saying I work for the General Counsel's office, so I do litigation, regulations, and some policy. So I worked a lot on the Music Modernization Act, including passing it and
That's awesome.
Well, I mean, you guys all know that I've been a pretty active member of the Recording Academy. I was a trustee. I just finished my term doing that, and I've been spending a lot of time over the years doing advocacy for musicians and helping to get musicians paid. And I know that the MMA, the AMP Act, and even now some of the things that are happening with the MLC, and you guys will hear a lot of acronyms, I think, but we'll try our best to explain all of them. But just know that there has been a massive what's the most PC way to put this? There has been a lot of lag in the way that music and art is taken care of and protected for musicians and artists, and this is why I was so jazzed to hear that the Copyright Office wanted to talk to us and talk to the audience that Music Expo has about ways to help protect our work because we are all freelancers. Dan and I work for hire. We don't get paid unless the musician gets paid, and the way that the musician or the artist or the songwriter get paid is through protections that the Copyright Office is able to extend to them for their work. So thanks again for being here. I think we should get started with some simple questions. What do you think? Okay, great.
Ready.
Hearing no objections, I will continue. My father is a lawyer. Dan's wife is a lawyer.
Yep.
Sorry.
We're pretty comfy with lawyers.
Yeah. May it please the stream and all of that.
There we go.
So, all right, we're going to start off with, let's talk about the difference between sound recording and a musical work. In just a few words, can you explain what our audience needs to know about the difference between a musical work and a sound recording?
Sure, and I'm sure that there's a lot of people in the audience that know this already. But as Holland has set up speaking engagements for me, there's been a range of people who include some people working with very famous musicians who have very basic questions about kind of the business and the law about copyright. And the one we always start out with is what's the difference between a musical work and a sound recording? Musical work technically is the underlying composition created by the songwriter or composer, along with any lyrics. And then the sound recording is a particular performance of a musical work that's been fixed in like a CD, digital file. We call it a phonorecord.
Okay.
So like the classic example is, Dolly Parton wrote "I Will Always Love You." When Whitney Houston recorded it, Dolly Parton still owned the musical work. So that's a basic difference, but it becomes really important in terms of, when we talk about like licensing later, we got to talk about the work at issue and then the right at issue. So that's kind of half the battle there.
Right. And I always harp on, a lot of things about royalties and how musicians get paid, but I feel like we should pretty much keep a lot of this discussion to how to protect the work so that then you can use it to get paid. But I don't know, can you tell us a little bit? I mean, do you want to hit a little bit on royalties and how music is monetized?
Yeah, the good thing about copyright is that in a lot of ways, you can monetize your works however your imagination kind of can figure it out, right? You can license a work for a flat fee plus royalties, only royalties. You can license the work yourself, use a publisher or a label, use an administrator. It's with some exceptions. There's a lot that you can do based on your imagination and what people want to use your works for. So there's because doing that all yourself, because people understand that's a little inefficient, and you should probably be sticking to creating more music and not the business of putting out music, because we want to hear more tunes, not have more accountants. Nothing against accountants, but they play the role. That's what I'm talking about. And so we have publishers who will license your musical works. You'll have labels who will license your sound recordings, but then there's also other organizations that are good to know about. And I think the first place that a lot of people have a relationship with in the business is their PRO. And so if you are a songwriter, to get paid for the public performance of your works, you're not going to go to all the different bars, all the different radio stations. You're going to get a PRO. And to start out, it's usually ASCAP or BMI, because they have to take
PRO.
Yeah, it was. What does
stands
PRO
for-
stand for?
acronyms. Yeah, Performing Rights Organization.
Right.
Okay.
So usually I was saying that people start out with ASCAP or BMI because they have to take all covers. There's a couple others, CSAC and GMR. Those are invite only. But mention them because I think a lot of people do know about them, but it's important to distinguish from, and they license all sorts of public performances. But I distinguish that from Sound Exchange, who licenses the public performances of sound recordings when it's made on a digital audio transmission. And that's a really weird thing about performances of sound recordings. There is no what we call terrestrial performance, right? So when the sound recordings played on the radio, AM, FM radio, you're not getting paid.
Yep.
So
Interesting.
Well, in the United States.
that is true.
Yep.
So
And a
Dolly-
couple of other places.
So the list has changed over time, but I think the two that are still on it are North Korea and Iran. So, we have pointed out the Copyright Office. I'm not breaking new ground saying the Copyright Office has pointed out that we are kind of unique in that circumstance. And certainly the office has supported a terrestrial performance right for a long time.
Right. And I understand that it really, the way that these terrestrial performance rights, we can hit on this a little bit later too when we talk about licensing, but the way that these work is it's all done in reciprocity, and so there's an entity that tracks these royalties and tracks the way that these songs are played. And basically, if you're a country that pays that royalty, then other artists playing in your country will get paid, and if you are a country that does not practice that reciprocity, then your artists are not going to get paid. And the United States is one of those. And there's something like hundreds of millions of dollars that are out there for United States artists that are played in these other countries that we should be collecting on. That's a lot of masters we could do with that money.
No lie.
Yeah. And the point is you would be double dipping if you had the terrestrial performance right in the United States. You'd be collecting that too.
Right.
And the foreign royalties as well. So
right. Yeah.
Wow.
It's pretty deep, right? And even if you've spent a lot of years in this, it's still kind of hard to track. So what about, so you're talking about terrestrial, like what about the difference between a digital sound recording playback somehow and a physical recording?
Right. So physical recordings are typically, if you were to buy a CD, that money flows through generally a record label. So the difference, and it's a little bit nuanced, but when something is used in a digital audio transmission, think.
Do we lose him? Oh no!
Oh no! Did we lose John? Or did we lose us?
I don't think we lost us. All right, so Dan's checking. Did we lose John? I don't know.
Okay.
Shoot.
Hmm.
Okay, so we know what to do in the event of this happening,
Sure.
right? Okay, this is fine. So one of the few of the other questions we're going to get that are coming in are going to be talking about these mechanical licensing.
Yeah, which is actually
that
the kind of stuff
John
that I'm
is
really
doing.
interested in.
Yeah, and there is actually, I'm hoping to hear from John about this. There's actually a new entity called the Mechanical Licensing Collective. So I'm definitely going to ask him about that, because we had a couple questions come in about that. And that has to do with the Music Modernization Act, which is some legislation that has just gone through. And a lot of that is around, mechanical licenses, physical copies, and a way of having artists being able to register with that stuff. And so you'll hear that acronym called the MLC.
The MLC.
Yeah, or the MMA is the Music Modernization Act, and the MLC is a Mechanical Licensing Collective. And we're also going to be asking John a lot of questions about, how to get your copyright registered, and the difference between doing a simple copyright registration and then registering that mechanical license. So I've got questions about that as well for him. So that's exciting.
I'm actually kind of curious too how, like, as he was saying, a recording, constitutes an entity of, like, that you can have a copyright on a physical recording. But at what point does changing that make it a new recording? If I make it louder, if I change the speed, if I EQ it generally,
that's a great
does
question.
That make it a new?
I think it's the recording itself and the master itself.
That's what
right?
I
because
would
that's
have guessed
what we're
too.
making, and that's what gets submitted. And I've had a lot of artists where they'll submit something early on, the mix, for instance, to ASCAP and BMI before I've even mastered it, and then they will resubmit the master after that. I think because of the length as well, like it's not, by the time we master it, and we cut it down. I mean, that's a good question for him actually too. We should also probably get somebody from a PRO to come on and talk about. Yeah, I have some friends at BMI that we could ask to come on. Well, we have a bunch of other questions. I wonder if there's a couple that you and I can just answer real quick.
Sure.
There was one about this one actually has to do with being paid, but it came in just today, and it says, among undiscovered artists and low budget record projects, how much should a producer be paid, an arranger, a mixer?
That's an interesting one.
Yeah.
Boy, that I don't know that I have an answer for it. I have heard a lot of different things depending on who the artist is and who the producer is.
Right.
At least in my experience, I have found lately the way that this seems to work is that I found producers to sort of be more the gatekeepers recently, where an artist will usually pay a producer to produce the record. I've seen some with points, but it seems to be a lot of flat fees too now. And that's just an agreed upon set amount. And that can be literally anything, from depending on if you're doing how many songs, but also just from producer to producer, that can be a very different amount of cost. As far as like the other people involved, I think that's just kind of, I think it's kind of up to those people. If it's a producer or an arranger or a mixer, you can negotiate with all of them separately.
I almost feel like it's a you get what you pay for kind of thing,
yeah,
right?
Totally. Well, I'm sure there are some people that you don't get what you pay for either too, but in general, I would agree with that as well.
Yeah. I also I think I was going to ask John, for the benefit of the audience, a few questions about, work for hire and what you own as on the, what you own on, for instance, when we make a master. We're work for hire engineers. Like we don't have any say or access as to what happens with that song after we're done mastering it. And that, I think, is one of the reasons why it's very difficult to get started and make a living, because you can't just do everything willy-nilly and expect to do it on a lot of producers will call it spec. So that's where they'll say, I want a percentage of the sales, or I want points on an album. And they will say, like, we are not really sure how much money this is going to make, but I know that you don't have what you need to pay my rate to make this, like profitable and exceptional to begin with. So I'm going to do it on spec and say, we don't know what, we don't know what we're going to do, but somehow I think this is going to be good. So I'm going to do it for free. So,
yeah.
And when the song makes money, maybe I can be recouped first, and then be able to hopefully recoup all the costs that it would have taken to charge for the record to start. But actually, I think they end up making a little bit more in the long run.
Yeah, especially if it's a winner project for sure.
Yeah. And the way that some of that stuff is done, I can talk about this a little bit. Having spent a lot of time working in the advocacy world. I'm not a lawyer. This is not legal advice, but there is a thing that has just happened called a couple years ago called the AMP Act that passed. Oh, John's back! Yay! And we're gonna ask John about the AMP Act, of course, and what has now changed for that. But that's really has to do more with royalties for producers and the way that spec work gets split up. So like the way it used to be, I know this, the way it used to be is a producer would have to take, I'm telling them about the AMP Act. So basically a producer used to have to take the artist's word for it that they were getting their splits from the songwriting or the recorded works royalties. And now with the AMP Act, which was unanimously passed, the artist can send a letter of direction straight to Sound Exchange to be able to pay out that royalty directly to the producer based on whatever their spec was or their split was. So we were telling them all about how artists, are working a lot of times on not really knowing what they're going to make until they sell it. But engineers like us, we work for hire. And so we don't really know what we're going to make. So sometimes we can do it, for hourly, but sometimes we do it on spec and then expect royalties to pay for itself later on. So that's where we left off. Welcome back.
Well, you guys like This is Spinal Tap? Because I just created my own version. Thank you. Sorry for the technical difficulties. It appears that
I was thinking maybe we said something wrong and the government
that was it.
Just pulled him right off.
Yep, exactly.
So Holland and I got kicked off at the same time. So we think that caused the problem. But
oh no,
I'm here. I'm on my regular.
Welcome back. Okay, so we were going to ask you to explain, to continue explaining about mechanical royalties, but what would be super cool is to also, so we can understand the difference between a copyright registration, and then what the Mechanical Licensing Collective is going to be doing and how all that's going to work.
Love talking about all that.
What's a copyright and what's a copyright registration? What's the difference there?
Copyright is the law that protects your works, right? And the thing that people may or may not understand is that you get a copyright when you fix the work in what we call tangible medium of expression. So, as long as you're not writing a poem in the sand, right, which is only a high school question that never really happens, you get copyright protection when you create the work. So there is important distinctions, and the most important one is that copyright does not necessarily give you all the rights that a copyright registration does. So if you register your copyright, it gives you rights to, it gives you the right to go to court in the first place. If you are a U.S. author, you cannot go to court unless you have a copyright registration. It's not the same.
Didn't know that.
If you're a foreign author, but if you're a U.S. author, that's the deal.
Regardless of medium, any.
Nope, it's regardless of medium.
Wow.
There's. I don't want to give you any independent answers. There's some caveats to the timing of when you need to make that registration, but the gist is that if you have a copyright registration, you could not only go to court, but you could potentially collect statutory damages. And everybody kind of, statutory damages are like the big bad wolf to some people. But what it really means is you don't have to prove actual damages, which could be really hard to do and cost a lot in discovery. And so statutory damages is a way that courts can approximate things. And if an infringement is committed willfully, it could be $150,000 per work infringed.
Whoa.
which, is a pretty good incentive to go to court, because otherwise, unfortunately, not a lot of lawyers are going to take cases if your work isn't registered before the infringement or within 3 months of it occurring. And, if there's no possibility to getting attorney's fees, which is the second part about copyright registration that's very important. There's also some evidentiary rulings. If you have a copyright registration for 5 years, it helps you, as a prima facie, got to lawyer it up, evidence of, that what's in the application is correct. But the big deals are going to court, attorney's fees, and statutory damages. So as copyright registration at the office, which we understand, not everybody registers their copyright. And, maybe we'll talk a little later about something that we tried to do to incentivize musicians in particular to register groups of works on an album. So it's a new registration that we wrote earlier this year. So
cool. Well, that's exciting. Very cool.
I'm really excited about it.
Anything that makes it easier for a musician, to just check all and send. I'm guessing it's probably a little bit more difficult than that, but
we can't make it.
All right, Dan, you're going to be up next after this next question that we've got here for John, and that is, okay, you've explained a copyright, you've explained a copyright registration. What about registering with the MLC? And we did talk a tiny bit while you were off about the MLC, but if you want to give a quick overview about the MLC and how and why registering with the MLC is different than a regular old copyright registration. Registration. Acronyms.
Acronyms. And roll back the clock.
Thanks, Carmen.
And back in the day, back in 1909 land.
Yeah, which day? It was a day that was a long time ago.
It was a long time ago. So Congress, in its wisdom, said, what, we're going to make sure that people who create sheet music have a copyright in that work, because we think that's a good idea. It will incentivize creation, and it doesn't matter that it's in the form of sheet music and not a book or a map or a whatever. But when they did that, they created at the same time the mechanical statutory license. And it's called mechanical because back in the day it applied to piano rolls, because they were worried about the piano roll monopoly, which is not a thing now. But it is a thing because there's only one company making piano rolls today. Did you know?
It probably is actually a monopoly now.
Well, this is also okay. So in 1906, correct me if I'm wrong, but the phonograph was made just before the turn of the century, right? And so even just having a recording of something was still pretty early. So the only way that you could protect your work was doing it on paper and on piano rolls in this case.
Yeah, sound recording protection, what we have of it came much later. But these are the days where we're protecting musical works, musical compositions, I believe is what the act called it then. And we have now a mechanical license where you can get, and this is the short version, but this is the regime that reigned for years and years and years, where if you filed some paperwork, reported on how many copies you made of the work, and you paid the royalty, the creator of the musical composition, once it was first published, couldn't say no. And that is still true for uses that are covered under the statutory license. You cannot say no.
Interesting.
So this went on for years and years and years, except nobody actually really used it, right? Nobody used the statutory license. Nobody necessarily filed the forms and went through the steps to get the Section 115 mechanical license. At one point, I think the Copyright Office had maybe a few hundred a year. It wasn't what's going on right now. And then the internet streaming hit, and in particular, interactive streaming, where there was a copy of the work created as a part of it. And so that would be the Spotifys of the world, the Titles of the world, companies where you can pick and choose the music. And so we had a problem on both ends. What had been taken care of, kind of not necessarily, maybe, but not necessarily using the statutory license in terms of the reproduction right for musical works, was taken care of through companies like Harry Fox, through Music Reports, and maybe a couple others. And there were a couple big issues because either services or intermediaries or others were missing the fact that works that were in the Copyright Office's records, which is a qualifier to get paid. They were either there and they didn't find them, or there was some sort of problem matching them. And then on the other side, if you are a songwriter, you might not get paid, especially if they couldn't find you, but also if you had, because you had to register your work or record your work with the Copyright Office to get paid as a qualifier. There were problems on both sides, and then the lawsuits started happening. And so, there were some class action lawsuits. There was a Copyright Office report. Everybody kind of said that the old song-by-song licensing system, totally inefficient. We're going to move to a blanket license. And so, much like, not exactly like, but much like a PRO, like ASCAP or BMI, says to different bars, festivals, radio stations, television stations, we're going to give you all the works in our repertoire, and you're going to pay us some money, and we're going to figure it out. Well, that's kind of the gist with the MLC. The MLC for those interactive streaming companies, it is a place where they can all go and pay for the works that they're using, pay the reproduction right. Now, this is not the public performance right, and it's only for musical works, but they pay the MLC the money. They also deliver some information that allows the MLC, hopefully, to match the musical work with the sound recording to figure out who is the right person to get paid.
Cool.
They keep a database of all that information, and then they pay out. Mm-hmm. And I think some people are a little confused or a little frustrated because there is a provision that says after 3 years, or maybe potentially for the first distribution, maybe longer, the MLC can distribute that unidentified, unmatched money, because its job is to match it to the people who own it. Mm-hmm. But if it isn't able to do that, maybe you don't come forward. Maybe you're just put out a song and put it on a streaming service and then forgot about it because your regular job is you work at the Copyright Office. Who knows? They would take any unclaimed funds and then distribute it by market share. Wow. And so that's a good thing to incentivize paying people, because the old version was that if you weren't in the records of the Copyright Office, you did not get paid. The new version is if you're not in the records of the MLC, the Mechanical Licensing Collective, they will do their best, and it is their job to go find you, and it is your job to come forward, and then you guys will meet in the middle and match all the information, and then you will get paid. But at least now, the services have to pay for every use, right? And they're not getting out of paying on some sort of technicality, even if the money is not going to if it's going to a person who has been.
Because there have been, I'll call them abuses. This might get a little editorial, I guess, but there have been some uses of loopholes in this law over the last 20-ish years for some of the some streaming companies and internet radio to be able to get around paying a fair amount for the recorded work that's helping them to earn millions and billions of dollars. And that you touched on it a little bit, which was the interactive stream. And so, one of the things that I want to know, and Dan and I were thinking about this when earlier, is the difference between a one sound recording and another sound recording of the exact same song and the exact same mix by the exact same artist, but maybe it was put out 5 years prior and this one's put out again. Okay, so what happens in that kind of duplicate scenario? And then also, can you maybe explain a little bit to the audience the difference between an interactive stream, so like an on-demand service, and something that would fall under terrestrial radio royalties and licenses?
Like Pandora, for example.
Like Pandora or Sirius XM, and even down to the point where when Spotify started a radio where you could just hit play on a radio based on a specific artist, very much the way Pandora works. Did that then put Spotify into a different license category?
Or curated playlists?
Yeah.
Wow, we gave you all here. Just talk for the next 30 minutes and no big deal.
This is what I do. So there's a lot of great questions. And I mean, let's take the first one about, if you have, let's say, a music work, and then there's a sound recording, and then there's another sound recording of the same nature. So, that happens all the time, right? Like people release works. And the question, I think, might be, is that protected by a new copyright? Like, does that reset the clock? The answer really is that it can, but the changes that you make have to be of a degree that it would be enough to trigger the, de minimis modicum of creativity that we call in the copyright world, where it can't be something like declicking a song, right? That's not enough. I can't tell you necessarily what it is, right? I can't, it depends on the song. If you added another part to the song, right? Another instrument, but maybe fixing the levels, maybe not, it's really hard to say.
Well, and then who is the, like, let's say this comes up, who is the determining factor if this ever became an issue?
So
or who makes that?
It's a registration specialist, and that's for copyright registration.
Okay.
If we turn down your registration, you can still go to court, and then a court would decide. So they might ultimately be the decider, but at least for copyright registration, and it's us. I said before that you can't go to court unless you register your works. It's also if we've declined your registration, you can go to court.
Sure.
Okay, so the reason that I keep thinking about this too, and I'm gonna ask you again and see what the answer is about this one specific instance. So the other day, I was trying to find Madonna's Borderline on Spotify.
Okay.
And we were having a heck of a time trying to being able to find the actual original version. All of them were remastered, or everyone we found was not quite the same. Like it seemed like a different vocal take, or the backup vocals seemed like they were from a different take, or were a different stack, or one of them was missing backup vocals in a certain part of the song. And so I'm like, okay, there's all these different mixes of Borderline out there, and obviously the song itself is protected, but at what point does each of these different mixes generate a new royalty, or is that a new license?
So,
and how do they track that?
They track it with something called an ISRC. So it's metadata for sound recordings that's applied into the file, and that's
acronyms. International Standard Recording Code.
We actually know that one. we use that all the time.
Ones that
we deal with those all the time.
Yeah. I love that.
We put them on the recording, all the masters that end up being your recordings.
And that helps when the MLC or someone else is trying to license a work or trying to track usage of a work. Metadata is supremely important and has just become more visible to the creator community as these issues have been discussed amongst everyone. Let me maybe clarify a little bit. So it's hard, I think, maybe to talk about music, but if I had the Mona Lisa, right? Mona Lisa is not protected by copyright anymore. It's in the public domain. But if I took the Mona Lisa and they let me in the Louvre and I was able to paint a fancy hat on her, what I would get the copyright in is the fancy hat, right? It's not the Mona Lisa. So if you're creating a new sound recording, the pieces that are new for like version 2.0 are the parts that you get the copyright protection in. And so here's the thing: if you're doing that to an existing sound recording, you need permission of the copyright owner, right? This is why we can't have remixes and allow that to discriminate against the original creator's rights. If you're creating a derivative work, that is a copyright owner's exclusive right. Now, tricky when you talk about fair use, but let's forget about fair use for a hot second. And think about it though. You have pretty famous Supreme Court cases on parody, right? Woman, and it's pretty much the song was taken and I won't say remixed, but it was a parody, and that is a different circumstance than if you are the original author and you're taking your own creative work and just adding on to it. You can do that. That's fine. But the new copyright is in the piece that you added on.
Whether it's yours originally or not, it's still in that piece. Like if I wrote the song, owned the copyright, and then added more, would I have 2 copyrights? One for the new stuff, one for the original?
And so what happens is when people do that and they register their works with us, they have to disclaim the original work.
Oh.
And so, it's one of the reasons that happens, just as an example, is if you have different authors of the works, right? Like let's say there's multiple authors of the works, or if it's a work for hire situation, and the measuring time for the life of the copyright might change. There's different reasons why that's true, but I mean, think of it. You don't want, Barbie with a hat versus with a backpack, and like every new time you added one little thing. This was a secret Simpsons reference if anybody didn't catch it, but but every time you like added a little small difference, that does not renew the copyright in the original, and it shouldn't. It doesn't. Sorry to talk about the Mona Lisa and Barbie when we're supposed to be talking about music, but that was easier to follow analogy maybe for me.
Totally.
Perfectly fine. Yeah. All right. So let's hit a couple of these user-generated questions.
Well, and so this one actually comes really well with what we were just talking about. So if I was you just mentioned a work for hire. So if I was contracted by an ad agency to write a jingle, for example, who actually owns the copyright to that jingle I've written?
So in a circumstance where it is truly a work for hire, right? It's not where you wrote the jingle and then you license it to them, or any other combinations where the relationship was not established beforehand. We'll just say broadly. But let's say the easiest example is you're an employee. Then the person that is considered the author of the work is the entity that hired you, right? So the corporation would be the author. So if you are an in-house person writing jingles, you are writing jingles for the business, and it is the business that is the copyright owner in that circumstance. Now, there's a lot of debate on what should or could or might be considered a work for hire, because if you're not an employee, it gets a little tricky. But in any case, I went with the cleanest example.
Yeah, I know.
Because that's the easiest one to talk about.
Well, and like all this stuff, you don't want to say it depends, but a lot of times it ends up in court, and I'm sure it's a lot of arguing about these exact things, and it probably changes depending on what deals were made ahead of time or whatnot. Yeah,
and the things court look at, might be things like health insurance. Whether you're considered an employee, might be health insurance. But
interesting.
There's different factors that the courts have certainly looked at, and that's why I gave the example of an actual employee, because it's an easier, cleaner example.
Yeah.
That way I don't have to say the D word.
We have another question about use.
Yeah, this one actually kind of is sort of similar. And this is something I've been curious about, because I've noticed, like, if I'm watching, I don't know if you're familiar with Twitch, the streaming service. I'm sure you are. Obviously you are. Never mind. Copyright. So they will mute, a lot of times if I'm watching a video of something on Twitch, something that's already been broadcast, they will mute the audio if there's a song that's copyrighted. But when I watch the broadcast live, I hear the copyrighted music. So the question that came in was, what are the copyright laws for playing covers live on Twitch or similar live streams? Okay, they actually said covers specifically, but let's do both recordings and covers.
Well, yeah, because there is a difference, right? So if you're the musical work owner and you're publicly performing a song that is not your song, you're performing the cover, but that is the right of the musical work owner, right? They have the right to license a public performance of the work. In terms of a sound recording, there is no, the sound recording, presumably if you're playing it, and by the way, very interestingly, a sound-alike recording is not a copyright infringement, right? You can create a sound-alike, and that's very strange, because I've known of artists, and I won't say who, but who have used the mechanical license to create a cover song and have recorded it, so they own the sound recording, but a different artist owned the musical work, and then someone came along and did a sound alike of their recording, which totally cuts them out of the licensing scenario.
Right.
It's an interesting quirk of the law.
Well, and I think about with Taylor Swift too, and her re-recording, those are very much sound alike recordings to me.
Yeah, exactly. So she would her or her team, I don't know who is involved in the recording process, but it could be her, it could be a label, it could be, her and others. Because when you think about it, the performer may or may not be the one recording the work, right? They're performing the work. But yeah, that's a circumstance where a new sound recording is created, even though it's based on the underlying original musical work. So it's very important. This is why we started talking about sound recordings and musical works at the beginning. I will say, I don't, without respect to any particular streamer, and I know that some streams are recorded and some aren't, and whatnot. Certainly, making a reproduction is an exclusive right of a sound recording owner. And as we were talking about before, the digital audio transmissions are the rights that sound recording owners have for public performance.
Right.
So depending on the circumstance, if there was a digital audio performance of a sound recording, that is potentially copyright infringement.
So like in a coffee shop?
So
like if I hear a John Mayer song in a coffee shop, who's paying John Mayer for that? Because so many people heard it.
Yeah, there are.
But it's only played once. So it's for public broadcast. So that's like a different kind of license, right?
It's an interesting question because it might depend in part on how the delivery is made. Mm-hmm. And that changes things, even though what you're hearing over the air is like analog, right? Mm-hmm. So if you used a service like Muzak might be paying for the digital transmission of the sound recording. And in any case, whether it's a digital transmission or if it's AM, FM radio, someone is still paying for the public performance of the music work. And interestingly, it might be both the radio station and the coffee shop. That's why you see, I think some people have seen stickers on bars and restaurants that say like licensed by ASCAP, licensed by DM.
Yep. What about okay, so I had a question, a sort of a follow-up question to the Twitch question, because one of the things that was asked or that you hit on was when it's played live, we hear the insert famous song, but when it's played back after, for reproduction later on, that song is cut out. Does that have anything to do with the DMCA, which acronym Digital Millennium Copyright Act?
Right. So presumably, and I don't want to get into the pieces where I think a lot of people know the DMCA for the notice and takedown provisions. You go to YouTube and said, this audio has been taken down, right?
Yep.
Or you'll alternately see no copyright infringement intended, which is not a thing. I don't understand that.
Weird.
Because the intent is not the only piece of intent that's relevant for copyright laws is if you commit copyright infringement willfully or innocently. That could escalate or de-escalate damages, but it's still do damages. It's
so
strict,
if I
we call it.
Steal someone's cheeseburger and say no cheeseburger theft intended.
Yes, exactly that. No other.
I'm fine. Yeah. Well, this is we're starting to get into legal advice territory. I feel like we should stay away from that.
Yeah, and the gist is that Section 512 of Title 17, which was the DMCA, is something that is generally Congress is looking at, and we are advising Congress. We wrote a report on this. So generally, I would reserve my legal advice for Congress, but people are welcome to look at that report online and see where kind of the tension points are. And certainly, when you see something like that, that would trigger my thoughts to whether someone's relying on Section 512 and the notice and takedown provisions.
Just for anyone who just wants to know, the Digital Millennium Copyright Act was made before the modern internet is a thing, and before streaming is a thing, and before Dan and I graduated from middle school, probably.
I don't know when did it become a thing? What year?
1999, right?
I believe it was. I want to say 98, but
see,
it's 12. Still, there you go.
So
that worked.
That's a long time for the amount of technology, music that's been made, and money that's been made on music for us to not have a lot of updates to that law.
The Music Modernization Act was for sure the largest update since the Digital Copyright Act, and the DMCA was the biggest update since the Copyright Act of 1976.
That's right.
Which at the time, and I'm going to butcher the quote, but the former Register of Copyrights Barbara Ringer said that 76 Act made a great 1950s Copyright Act. So
we're always a little behind.
There's a little lag, but we got a lot of people at the Copyright Office who are actively advising Congress all the time on the issues that are affecting people and getting them up to speed and answering their questions. And what we do a lot of is hear from creators and creator groups, and that helps inform our and frankly users and services and those types of public interest groups as well. And all of that information informs our advice to Congress and informs our rulemakings and informs our policy studies. So it's a pipeline. The Copyright Office is more than registration. It's a pipeline to a lot of important policy that's going on in DC.
I'm really happy about all that. There's been a lot of activity that's happened in the last few years that is helping. It really is, and I'm starting to see things change. I'm starting to see people caring about it more. So thank you for all the work that you guys are doing. Should we ask him one or two more tough ones? There's so much to cover here, right?
What is a good tough one?
How about some stuff? How about international registration questions? I got one via text.
Oh, I do not know anything about this, so
I got one via text just now. How important is it to think about copyright rules outside of the United States, both by owning registrations or paying royalties for covers, etc.? It's an international maze of horrors, honestly.
Well, it's a very good question, and approaches in other jurisdictions are governed by their national laws. But we have copyright relations, we'll say, like treaties.
Okay.
With a lot of them. And so, as we were talking before about sound recordings, works protected in the United States will also be protected in other countries. And in fact, that's why we have like a life plus 50, measuring period for the life of a copyright, the author's right plus 50. But that's a different question about how do you get royalties from other countries. And, if you are a foreign author, you may be able to register directly with their PRO or their CMO, rather, collective management organization. And so these organizations have different jurisdictions as well. But the good news is that unlike the United States, for example, for musical works, it's typically more of a one-stop shopping. So there'll be licensing, and by that I mean collecting royalties for and then distributing monies for both the public performance and the mechanical right at the same time. So we have the MLC, and then we have our PROs, ASCAP, BMI, CSAC, GMR. Many countries have one organization, and they do that both. And so, depending on different relationships, different direct licenses, whether you're a publisher or a label, you may go and establish relationships either because you have a subsidiary in a different country or because that you have agreements as a PRO with a different PRO in another country. It gets a little complicated, but the long story short is they collect royalties a little bit different, but it helps to, and this is very much a circumstance where it helps to have a prominent publisher and a prominent label because they know those relationships and are able to leverage them to get you paid.
Wow. That's a lot. I'm glad that we don't have to deal with this on a daily basis, but
is this all lengthy answers?
No, this is
great.
Wonderful. I mean, I'm just like, the amount of nuanced information that you have in there is just a lot.
I say it's like an onion, not because it has layers, but it makes you cry.
That's awesome.
I've got questions about the Case Act, and the Copyright Claims Board and how to get your views heard. So do you want to take a couple minutes and explain the Case Act, and talk about, what to do in the event of, conflict and things like that in the future too?
Sure. And this is really near and dear to my heart because what became the Case Act was based on a Copyright Office report that I helped write. So
awesome.
Called Copyright Small Claims. I know,
cool.
right? Came out in 2013, and there were 4 of us that really contributed a lot to it, and it had model language in it at the end. that Congress used as a basis for its law, right? But it really talked about the problems that people have, like enforcing the copyrights. As I mentioned before, you need to register work, but it's also things like I alluded to where you really need a lawyer because you have to enforce copyright in federal court. You can't go to state court. There's no small claims court in federal court or state court to handle this. And I don't know if anybody has gotten a lawyer before, but it's really expensive. And some of them won't take it unless they think they're going to get a certain amount in damages. And that number tends to be around $40,000. Wow. And a lot of infringements are not of that level, right? If you had, a song that was licensed for, X amount of uses and they went over that, it might not hit that $40,000 threshold. Or if you're a photographer and I think the classic example is, you had certain uses for wedding photographs that cost, you got package A, package B, and maybe you exceeded that and went to package C, and it's not going to hit up $40,000 total, but you want to get paid for your work because, the difference between selling package A and package C, it might be $1,000, and that adds up, right? And so we talked about kind of the different challenges of creating solutions to that and looked at other jurisdictions. And what we came out with at the end was to have a voluntary system. And what we did say to Congress that this system could be opt-in or opt-out, and Congress chose opt-out. And so what we're setting up right now is a system that's essentially a small claims tribunal, but not a court. It is voluntary. It will be headed by 3 copyright experts because, well, there's a couple jurisdictions that have a lot of copyright cases. For example, Wyoming does not. It has 1 or none a year, right? And so that's not to say that the judges are not expert in being a judge, but they're certainly less familiar with copyright cases than other cases. And so the premise is you come to the Copyright Office, to the Copyright Claims Board, and you say, I have a copyright claim. And the people who will be employed there, and they're not hired yet, will look at the submission and say, okay, this is copyright, this is not trademark. It hits all the legal things you need to know, and we'll give some guidance on what qualifies in terms of what you need to prove. And then the respondent is served, and they get this official notification from the government that says, hey, this person has come forward and they have a dispute over copyright, and is offering for you to use the Copyright Claims Board because the cap for damages is a lot lower. I talked about $150,000 per work infringed if a work was infringed willfully. At the Copyright Claims Board, per work, it's 15. So it's 1/10 of the total damages that could be awarded in federal court. And that's a huge incentive to people. The fact that the board is composed of copyright experts, it's designed to be more efficient than federal court. It's going to be designed that you don't necessarily need a lawyer, although you could certainly have one. And it's hopefully going to allow people to get an official ruling on something where, there's just a dispute. And this could be any different flavor, right? You could say, well, I thought I had package C and not package B. And, you promised me that I could use more in whatever different circumstances. You're not clogging up the federal court's time. You're going to get something that's decided by copyright experts in an efficient manner, and then move on and create more works because that's what we want y'all to do.
Yes.
Awesome.
Oh, I love that.
But it's not available yet. It might be as early as December 27th of this year, though. We had a year to implement it, and that's what I do a lot of these days, although we can extend that date for 6 months if we need to, for example. So.
Wow, that's awesome.
Do we have any questions from the group here that we want to hit on real quick before we wrap this up?
It looks like most of these have gotten hit on
okay.
For the most part. Also, just wanted to. This just got put into the chat by Holland, but there's a lot of info on your website. Is that right, John? This is where if a musician or artist could go there to find a lot of resources on this.
Yeah, and this is what Holland's been working on a lot. Is both there's a website for the Copyright Claims Board. I think it's copyright.gov/copyright small claims. Holland will put it in the chat, and then there's another resource, as I was kind of alluding to before. We created a lot of informational materials on the MMA. And then we realized there's a lot left to fill in. And so there's handouts on how to get paid that talks about the different royalty streams and what you need to do to get paid by Sound Exchange, the MLC, a PRO, how to get those unique identifiers and match them to your works. So when you put them out in the world, people can find the breadcrumb trail and find you. And this was all started, I'll say, because Congress charged the office to go out and talk about the MLC and let people know that, if you're a copyright owner, you need to go to the MLC and register your work so you can get paid. And that is, if I could give everyone one takeaway on that, it's go to the MLC and if you're a self-administered songwriter, especially, go there and understand the system. They have a lot of good information on their website too. Register, match your sound recordings to your musical works, and then wait for those mechanical royalties to come in. I will say that if you have a publisher or you are not self-administered, talk to your publisher or administrator, and that's what they're responsible for. So we don't need multiple people working, to have this end. But it's new, and it's really important to know about. And so that's why we're out here talking to everyone and filling in the pieces in between.
That's awesome.
Well, thank you so much. I mean, I'm really, really glad that this happened, because I can't think of a better person to have explained all of this stuff. And it's definitely one of the things that Dan and I have not been able to hit on a whole lot over our No Stupid Audio questions. We get a lot of questions about protecting work and protecting future income and stuff. So thank you so much for being a part of this and for reaching out for us to talk to you.
Thank you so much. It really was my pleasure.
Boy. And thank you to Loic and Music Expo. I hope I'm not infringing on.
No, and we were just able to get the web addresses into the chat as well for all of these spots.
And thank you, Carmen, for running the stream here for us. You're always wonderful, making this happen for us, and Loic for running Music Expo, and for Holland for reaching out to us to connect everybody. It's very cool.
Yeah.
Thanks, John. All right. Well, I think we will call it an evening then at that. Unless you have any other last minute advice, John.
I think you might have
a lot.
Create more works. Get out there and make stuff, because we're in a pandemic, and I want to come out of pandemic with the best music ever. So
yes.
Will we be joining the Discord afterwards?
We should.
Yeah. So I don't know if you're available, John, but we normally join kind of a quick Discord for 30 minutes or so, just to chat with people, a little meet and greet with some of the people who are on the stream if they want to join. And
have a little interactive talk about, what came up.
So no worries if you can't, but and for anyone who'd like to, the link just got thrown into the chat, but it's the Music Expo Discord channel, I believe, or you can follow that link.
And you can find us in the video area of the, I think Lloyd does it on the ME Lounge.
Yeah.
You should see some activity, and you don't need an account to sign into Discord. You can just sign up with your name, and it'll let you right in. So yeah, we'd love to see you if you're available, and Holland as well, of course. You're welcome.
And
all right.
We'll be back next month for
we will
probably a more audio related one. But this was fantastic to get this perspective for sure on the music industry.
Yes. Thanks so much, John. Thank you to the Copyright Office for lending you to us for an evening, and thanks to Music Expo. We'll see you guys soon.
Yep.